Hey folks, James Abrinio coming to you from Abrinio Law, your Northern Virginia personal injury and criminal defense law firm. Got my information here for you. So if you have any questions, you can reach out, and also make sure to subscribe to the YouTube channel. We're trying to get more people involved so we can have more impact. We can get more information out there. And this morning I wanted to come to you about a quick decision that I just saw as I'm scanning our local trade magazine, Virginia Lawyers Weekly. An important case just came down the pike. It's Rogers versus Commonwealth, and I'm going to go ahead and share this with you. It's a very important opinion as it comes to the definition of assault and battery here in Virginia. How do you define assault and battery? There's a lot of confusion about how it works. There's a lack of clarity as to the actual definition of assault and battery. So I figured let's go ahead once these opinions come out, and if they're useful, I can go ahead and just share them and show you as I'm reading them kind of what they're about. Maybe get a little more information on how you can actually read an opinion itself. But as you can see here, this is coming from the Court of Appeals of Virginia. It's coming out of the Circuit Court of Roanoke, the city of Roanoke. Essentially what that means is somebody was tried for an assault and battery. It looks like Sil NMM Rogers. Not sure if I'm pronouncing that right or if it's spelled right. But essentially looks like Mr. Rogers went to trial in the Circuit Court of the city of Roanoke. He was convicted by the court, and then they appealed it. So that's the reason we're up to the Court of Appeals here. And the Court of Appeals on August 9th of 2022 wrote an opinion essentially upholding that conviction. As you can see here, appeals his conviction for misdemeanor assault and battery under Virginia 18.2-57. So essentially he challenged the sufficiency of the evidence, and why this opinion is important. As we've written before and we've talked about before, Virginia's assault and battery laws aren't necessarily as clear as you would think. There's not a statute that actually defines it. It's actually defined by essentially what we call common law. So decisions coming out over the years helping define the law. So with every opinion, there's going to be essentially a background factual section. And then there'll be, as you go towards the bottom, there'll be a legal analysis, and walk through this in just a moment. But when you're looking at these opinions, this is what we're looking at. So the first part is essentially the background. That's really what happened. And here, I'm not going to get into the details. I'm going to share the link to the Virginia Lawyer Weekly article below, so you can pull this yourself. But essentially, it sounds like on October 3rd of 2020, so this is Halloween, almost 2 years ago, I guess the complaining witness, the victim here, Jessica Thurman, is with friends in a bar, and this Mr. Rogers decides that he's going to make some type of advance upon her. And so I've highlighted kind of the most important factual allegations here, which are now factual findings because the Court of Appeals have upheld them. But we'll kind of summarize through. But obviously there are more facts in this. But it says here Rogers approached the group and grabbed Thurman's wrist. He told her to let him buy her a drink, which she declined. Rogers then, quote, pulled her close and asked her for a phone number. Thurman refused. Rogers then whispered in her ear, "We should go blank." After, you can read that right there. After this, Thurman told Rogers no and reiterated that she was going outside with a friend. So as you can see here, this type of assault and battery is not the situation where you have somebody alleging that the other person punched them or shoved them. This is more an inappropriate touching type behavior where there's physical contact, and it's not a consensual contact. It's done in a rude, vengeful manner. Going on, Rogers ignored her request and began fondling her buttocks, kissing her neck, kissing her cheeks, instructing her to kiss him on the mouth. Just a quick point there. In Virginia, there's assault and battery, but there's also another misdemeanor allegation, what we call sexual battery, and that's a physical assault done in a way that's meant for essentially sexualization. And I don't have the actual terms in front of me, but with a sexual battery charge, there's an additional element of essentially you're doing something and committing battery with additional intent of essentially doing it for sexual gratification. There's at least an argument here, at least what I'm seeing, that this could have been a sexual battery charge. I can imagine that they didn't go forward because it can be hard to actually convict of sexual battery. So it may be the prosecutor just shows let's get them assault and battery to not complicate things. The worst thing you want to do, not the worst thing, one of the things you want to do, I think, as a prosecutor is not, when you can get somebody of something, not going beyond that and putting yourself in a situation where you may risk an acquittal. So, but I am seeing here these allegations, or at least could be alleged, this is a sexual battery going on. But Rogers continued to touch Thurman's buttocks and back and repeatedly told Rogers to stop and tried to pushing him away, but he ignored her request. Eventually, Thurman managed to get away from Rogers, and she contacted a police officer. So again, we're just summarizing this, the broad points. He argued, so now we're talking about the actual factual events at trial. So at the close of the Commonwealth's case in chief, essentially after the government puts on its evidence, a defendant can move to strike evidence, claiming there's not, even assuming everything is true, there's not enough evidence to meet the elements. He argued here that after the Commonwealth's evidence that there was no evidence of really an intent for unlawful touching. He characterizes behavior as, quote, engaging in a sort of social norm for a night of Halloween at a bar, quote, end quote. Rogers also argued that he did not have the intent to commit battery, but instead merely trying to engage in some sort of relationship and, quote, gave up after a short period of time. And again, this is what he argued at trial at the motion to strike. Circuit Court, the trial court said no go, and they overruled his motion to strike, and they went forward, and ultimately the defendant was convicted here. Now on appeal, this is where this is the analysis section of the Court of Appeals, where you're seeing the defendant, the now convicted defendant, challenging essentially sufficiency of the evidence, and this is the court setting out the standard. When reviewing the sufficiency of evidence, the judgment of the trial court is presumed correct and will not be disturbed unless it is plainly wrong or without evidence to support it. What that means is, if you're convicted in a trial court and you're claiming that, look, the trial court just got it wrong, there wasn't enough facts and evidence to convict, the appellate court is going to give deference to the trial court. And in a lot of ways that makes sense, because the appellate court's only seeing the papers in this document. They're only seeing the written record. They're not seeing witness credibility, witness behavior. As we all know, communication, a lot of communication and credibility and things like that come through other social cues and other communication cues, not just the words that are being said, but the way somebody's face looks, the blink of their eyes, the hesitation in their speech. So the appellate court doesn't have the benefit of seeing that, and so when you're looking at an appellate court reviewing a trial court's decision, when it comes to factual findings, not rules of law, but factual findings, they're going to give deference to the trial court. And here, when you're challenging sufficiency of the evidence, as the defendant did here, you're challenging the factual findings, so there's going to be deference given there. Now, the appellate court goes on to say that in such cases, the appellate court does not ask itself whether it believes the evidence at the trial established beyond a reasonable doubt. Rather, the relevant question is whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And so essentially, again, it's essentially saying that could any trial court have found it, not just this trial court. So that's even further deference. Now, the court then goes on to define the black letter law of assault and battery. And again, this is coming from common law. So assault and battery are common law crimes. This is saying a conviction for battery, the Commonwealth must prove, quote, willful or unlawful touching of another. The touching does not need to cause physical injury. Again, there needs to be no allegation of injury. An injury to the victim's mind or feelings is sufficient. If a victim consents to the touching is not unlawful, therefore not battery. So, look, you can have a physical touching that results in injury, but if it's a consensual touching, it's not a battery. If the touching exceeds the scope of the consent given, the touching is not consensual and thus is unlawful. So, let's say somebody says you can kiss them, but then you go beyond that, that's a battery if they did not consent to that. Furthermore, it's the intent of the actor, not the force applied, that determines whether a battery has occurred. And just a little bit more information, the intent of element of a crime may be proved by circumstantial evidence. So that's Testimony of both the accused and the defendant, if the defendant chooses to testify, witnesses, all that, whether it's bruising, photographs, video, all that stuff, so they can go into factual findings. So then the court essentially applies its legal analysis to the facts of the case. Here, the evidence showed that Thurman refused Rogers' first 2 requests to have a drink. Rogers grabbed her wrist, pulled her close, and whispered in the ear they should, quote, go blank after this, end quote. Thurman unequivocally told him no and walked away. In response, Rogers began caressing Thurman's buttocks, touching her back, kissing her back and neck and cheek, while Thurman continued to tell Rogers no, to stop, and tried to push him away. Thurman's testimony was that Rogers and continued touching her over repeated objections. And again, I'm just summarizing. This evidence supports the circuit court's conclusion that Rogers intended to act in a rude manner, and Thurman and her multiple requests not to do so. So again, the court is upholding the trial court's conviction. That should tell you, and hopefully this analysis, look, as you can see, the opinion itself was pretty straightforward. It's only 5 pages and double space. So the rules that the Court of Appeals is laying out here in this decision, and it's an unpublished decision, but that's a little more technical than we need to talk about in this video. But essentially, it means it carries a little less weight. But the rules there apply. It's very kind of a simple analysis in a case like this. Look, there was a touching that was done in a non-consensual manner. The victim here is saying, look, I don't want you to touch me. I don't want to go forward. I don't want to do what you're asking. And despite this, the defendant keeps going. And so I think the court got it right here in assault and battery. This is certainly an assault and battery conviction. In fact, there could have, in my view, arguably been less touching that could still constitute assault and battery here. The other thing is, again, there's a possibility this might have been a sexual battery. Again, the prosecutor probably made a strategic choice not to go to the sexual battery because if you lose that, it puts your prosecution at a bit more risk. And I imagine they chose, and again, I can't speak for them, but if I'm a prosecutor, I'm thinking, look, let's get the conviction here. This will do what it needs to get done. And I think that's what they end up doing. So, look, hopefully this provides you a little more information about how Virginia defines assault and battery. Hopefully it also provides you a little information about how I read legal opinions, how lawyers read legal opinions. As you can see, an opinion like this is pretty straightforward as far as analysis and understanding it. But just be aware that Virginia is coming out with opinions like this all the time as cases are being appealed. But I think this was a pretty straightforward assault and battery conviction. But again, it just lends light. Again, I'm still surprised that the Virginia Code doesn't define assault and battery. So you look for these opinions to help decide. So, look, folks, I hope this was useful. If you've got an assault and battery charge pending against you, or let's say you were the victim of an assault and battery and you're trying to understand the law better and you're trying to figure out what prosecutors are thinking or about how opinions are read and written, hopefully this was useful information. If you want to contact me, here's my information down here. Make sure to subscribe to our YouTube video. We're constantly adding more content. And as you can see here, I'm doing this essentially on the fly. I don't have my fancy suit on. I'm got my virtual background in my office, but I'm not in there. So we're just trying to get this done for useful information. But hopefully this is useful. Take care, guys. If you need anything or if you have any questions, reach out. Thanks. And let me end this without messing it up. Thanks.